are getting started here. My name is Melissa Rosenberg, and I'm here to help facilitate this webinar tonight. We are going to be talking about doing a financial deep dive into your family law case. First, I'm going to introduce myself real quick, and then I will turn it over to Michelle, who will be leading our webinar today. My name is Melissa Rosenberg, and I am a therapist actually in private practice here in Seattle, Washington. And I do have a specialty area in working with clients who are navigating the divorce and separation process. I work with clients at the beginning who are trying to determine whether their relationship is able to be repaired or if they are moving forward into the divorce and separation process. I work with people throughout their family law cases, and I also work with clients on the other end who are navigating their next new chapter. So I do enjoy working with the population and providing support. But today I'm here as a moderator for this webinar. And so I'm going to turn it over to Michelle to introduce herself in just a moment. Just want to give you a little bit more information about how today's going to work. Basically, Michelle's going to deliver a lot of great information around finances when it comes to your family law case. But you may have questions that come up along the way while you're listening. And so if you do have questions, there are two different ways to ask them. There's a Q&A button at the bottom of your Zoom screen, and you can ask them in that way, going ahead and putting the question into the Q&A. If you do that, then, it will show up with your name, or you can mark that you'd like to be marked as an anonymous attendee. So that's an option as well, if you'd prefer that your name not pop up in conjunction with your question. The other option is if you'd like to ask the question in the chat, go ahead and do that. The chats will only come to me, so those won't be seen by the other people in the webinar. So any questions that are asked, we'll do our best to answer as many of those as we can, and hopefully leave you guys with a lot of great information today. So I will turn it over to Michelle Dellino of Dellino Family Law Group to lead us in this discussion. Thank you.
Hi, I'm Michelle. It's nice to have all of you here today. I am the owner of Dellino Family Law Group. We're a full-service family law firm. We have 10 attorneys. We have offices in Seattle and Bellevue, and we serve clients all over Washington State. So the point of the webinar is to give you some basic information. Nothing in this webinar should be construed as legal advice. We aren't forming any kind of attorney-client relationship by virtue of you being here. And again, like Melissa said, if you want your questions to be answered privately, she's told you how to do that. And keep yourself anonymous. You shouldn't be able to, and you can't see the other participants that are logged on to the webinar, so no one knows that you're here unless you tell us that you're here. We know, but no one else knows. So anyway, long story short, we're going to give you some information. We're going to talk about financials today. I've been practicing family law for 15 years, and I have come to realize that there's just so much confusion about financials, even for people who might work in finance, or even for people who might feel like they have a facility with numbers, how those numbers work in a family law case and what you need to have and what you need to know can be very confusing and very overwhelming. So we're going to talk about a little of that and get into it. But again, nothing here I'm telling you is legal advice, and you can ask questions, and you should ask questions. But if you ask like what I like to call hypos, where you give us some very fact-specific situation and you want us to analyze it, I'm not going to be able to do that here. It wouldn't be appropriate, it wouldn't be ethical, and it wouldn't really be helpful for you. You need to be able to have an ongoing dialogue with an attorney if you have fact-specific questions. But we'll try to answer some general questions that might help everyone. I'm going to go through some content. We'll take a few breaks to ask questions in there. I don't anticipate this will be an hour, so we'll be able to get you on your way before your lunch hour is over. So that's the whole idea. So anyway, we're going to talk about financials. And people often ask me in the beginning, what do I need to know? What financials should I gather when I get ready to start a family law case? This is a very basic question. And one thing I want you to know is you're going to have to provide financials more than once in your case. A family law case is a marathon. It's not a sprint. So that means when we capture financials and their statements, it's a moment in time. So those financials are going to need to be supplemented later in your case. And I'll tell you why. It's important, I think, that you understand the why behind things, not just because I said so. It really is a why. It's not to make things difficult. It's not to have you spend more money to keep sending us statements. It's actually really not any of those things. And depending on how long you've been separated as well, can create another layer of complexity. The longer people are separated before they move forward in their case, which is fine. I've had clients be separated for years before moving forward, but it does create added complexity and sometimes added cost for you because we'll need to do different valuations, and we'll get to that. But anyway, long story short, you'll need a set of documents to get you started. And what do you need? I'll tell you what you need. If you've been separated a while, you're going to want to have statements that I'm going to talk about that reflect the date of separation when you separated. And then you're going to want to have current statements. And when I said you're going to need to keep supplementing those, if you give me current statements now and date of separation now, that's all I could ever ask for. But then if it's 6 months before we go to mediation and get everything done, we're going to need current statements again at that time. So you might need to update your statements. If opposing counsel asks for discovery, you might need to supplement your discovery all the way up till you go to a trial or a mediation. That's very normal. It's important to know that all property is before a court. So what that means is you might have saying, yeah, well, we separated 3 years ago. Right, sure, maybe you separated 3 years ago, but the court or a mediator, or when we're doing settlement, even if you're not in either of those settings, the other party, you need to have financials that are reflective of your entire financial situation, including separate property and post-separation property. So you're going to have to show, if you've got money after you separated and it was 3 years ago, going to have to show current statements. So that can be very frustrating for some people. They don't understand why. They don't think it's relevant. It's not my rule. It's the way that the law works, and it's what the court sees. And all properties before the court, so the court needs to have that to inform what will be a just and equitable division in your case. Okay, so you're gonna have to supplement statements. You're gonna have to provide statements more than once. Data separation statements are going to be important, and current statements are going to be important. And obviously that current statement date can change. So that's just basics that I like people to keep in mind, because it can be very confusing for people and very frustrating. Okay. But what do you actually need? Well, what you need in the beginning might not be everything that you need long term, but let's just talk about that. I really like to use as a starting point the financials required in Local Family Law Rule 10. Now, you don't need to worry about Local Family Law Rule 10, often called LFLR 10, but you might hear that thrown around if you have a King County case. That's a local King County rule. And it's some other counties do have different rules on financial disclosures, but basically, LFLR 10 says that anytime a party is seeking financial relief, they have to provide a certain amount, a certain set of statements, right? And so I like to use that as a starting point for you in figuring out like what it is that you need. First thing, very basic, you are going to need your pay stubs for the past 6 months. If you don't receive pay stubs, you'll need any other documentation to show income from whatever source that is, and any deductions from earned income for that period of time. So start with 6 months. I actually recommend you go for a year. Because especially if you have bonuses or other things that are not paid out in 6-month increments, like a year is great, but 6 months is going to be the bare minimum. You're going to need to supplement that. Personal tax returns for the prior 2 years, and that should include all schedules and all W-2s, not just the summaries, so everything. 2 years is great. If you own a business, basically, I think the rule is actually 5%. If you have more than 5% interest in a corporation, partnership, or any other entity that generates a tax return, you're going to need a tax return for that too. Some people might have a business, some people might have like a holding company. Whatever it is, you're going to need a tax return if you have more than 5% ownership. And go for 2 years there as well. And it doesn't mean that you're not going to be asked to produce further than 2 years, but 2 years is a really good starting point. We can also tell a lot from looking at a tax return. I can tell what retirements you've contributed to. I can tell what you probably have a taxable account. I can tell a lot. So, and so can the other party. So 2 years tax returns is a great place to start. And then if you've received any kind of taxable income or benefits as a result of a trust, gifts, or anything like that, you'll need documentation to show receipts, the source, and any deductions for the last 2 years. So not everybody has that, but any outside non-taxable income or benefits for 2 years, you're going to need to show as well. Anyway. Check registers as well. If the other party requests, you might have to supply those, but that's really like that's pretty atypical. Finally, the biggest thing that you're going to need to do is provide 6 months of statements for any account where you have any financial institution for any account that you have an interest in. This is banks, credit unions, mutual fund companies, brokerages, which includes retirement accounts, any account that you have an interest in financially for 6 months. And you also are going to want to make sure you provide debt accounts. So 6 months of mortgage statements, car payments, home equity line of credit loans, any account at all that you have an interest in, whether it's a credit account, a debt account, an asset account, a tax deferred account, and I don't care. Get them together. How do you do that to save on fees? This is a really good question. Go through, put together a folder that's your folder of statements, and then have subfolders. I recommend that you take those subfolders and you name them with like BOA, Bank of America, the last 4 digits of the account number, Fidelity, the last 4 digits of the account number, and then go through and do October Fidelity and really organize your statements. It's going to save you time because we have to have them organized. And the closer that you are in doing that, the easier it is for us and the less time you're going to have to spend. If you just dump us a bunch of stuff, it's not labeled, we have no idea what it is. We have to do that, and that's going to take time and money, so you don't want that. But getting that 6 months of statements for every account, it also includes Venmo, Cash App, all of those kinds of accounts. If you don't, eventually, and you withhold them, and someone requests them through a discovery request or whatever, someone's going to subpoena them, and you're going to end up paying for that. So get your financials together. That is like the best thing that I can tell you. You're also going to be required to do a financial declaration. So I want to talk about that. Melissa, are there any questions as we get started? I can't hear you.
Sorry about that. Not yet. We're looking good.
Okay, perfect. Love it. Okay. So as you think about moving forward, you need to think about what else you're going to need to do. You're going to need to do a financial declaration. You're going to need that for a mediation. You're going to need it for settlement discussions, even before a mediation. You're going to need it if you ever go to court requesting any kind of financial relief, whether that's on a temporary basis or in a trial setting. What is a financial declaration? A financial declaration is where you're declaring your income and expenses. And then the interesting thing about it is all of those financials I just talked about in Local Family Law Rule 10, those are what we call the financial source documents. Those are the source documents that have to back up what you put in your financial declaration. So the declaration is going to ask you, how much do you spend on food a month? What are you, and it's really important because it's what your anticipated expenses are post-separation if you haven't separated. So maybe you haven't separated. Well, how much is it going to cost you to live on your own now? How much do you think you're going to spend on food? And you need source documents to back it up. So you can't say, oh, I have a car payment that's $800 a month, but your financial source documents say your payment's $350. No. If you have no car, and you're going to get one, then you can estimate what that's going to be. That's fair. But it's important to know that you need the source documents to back up what you're claiming. So that's very important. Financial declaration can be confusing. It also can really kind of come back to bite you if you do not a good one or inaccurate and you're in front of the court. So it's really important that when you work with an attorney, you take their guidance. If they're telling you to, like, oh, I'm not saying anyone here is doing this, but they want to see reasonable expenses. If you're like, well, I spend $600 a month on Botox and skin treatment, that's great if you really do, and you might have the statements to back it up, but a court's not going to want to see that when you're going through a divorce, and that's not a necessary expense. You're going to need to stop, and don't put it on your financial deck unless you want to look bad. So there's little things like that, or if you're going to claim a certain amount for food or eating out or whatever, you need to be reasonable with your expenses. And so, your attorney can help you do that. You also are going to need to be clear about what you're disclosing as far as liquid assets and other things, especially if you're asking for some kind of relief from the court and the other party. So that's just something to know. When do you provide these things? Get it together in the beginning. You're going to be asked for it by your attorney. You're going to be asked for it before any kind of settlement. You're going to be asked for it for mediation, and it's going to be required for that, and it's going to be required for a trial. So you need to have all those things. If you go to a hearing where you're asking for, like I said, spousal support, child support, attorney fees, any kind of financial relief at all, you're going to have to provide financial source documents and a financial declaration. So there's going to be numerous times when you could need those documents. Then we talk about documents and financials as we move on to settlement. And we start to think about settlement. And, you can settle your case sometimes through negotiation, although not very often, because people do better, I find, negotiating multiple issues in real time. But sometimes you can send a settlement offer and sometimes someone will accept it. That happens. But you also want to think about, since we're talking about financials, making good usage of your money and time. And you might really want to do that. You might not want to go to a mediation or a trial, and most of you won't go to a trial, but most of you will go to a mediation, and you might not want to, but it's a much better usage of your time to do that and spend one day to do that than to spend many days of sending back and forth proposals and not getting anywhere and hours and hours and hours on that. Because then you're not doing it in real time. People are thinking about it. Nobody has any pressure to do anything. People are coming back. And you could spend hours doing that and get nowhere and then still have to go to mediation. So that's why if you make a meaningful effort to settle, that's great. But when it's not going to happen, it's much better. Your resources are much better spent doing it when you actually are able to negotiate in real time and also to bind someone to a settlement. And that's super important. So that's just something to think about when we talk about the expenditure of attorney fees, which is a real thing in a divorce. It's important to also think about as you move towards settlement and those kinds of discussions that you want to spend your money wisely. And this comes up a lot. A lot of people are like, oh, I don't want to spend money to do valuations. I don't want to spend money to value separate and community property, which we'll talk about in a minute. But if you don't, you can't trace it. If you don't have anything. You can't stand up there and give your own testimony about what you think the calculations are because you're not a qualified expert. So, and without a report, the court is not going to be able to distinguish between separate and community property, and the court's not obligated to do their own calculations at all. You bear the burden if you want to trace separate property. And a lot of time, when does this happen? We'll get into this in a minute. This happens most commonly with a 401k or some other kind of interest-bearing account, whether it's a retirement account or a taxable account, where you might have an account where that you had before marriage, and then you put money into it during marriage, and then maybe it was even after marriage, it's, post-separation, or maybe you rolled over a separate property 401k into a community one. Any number of reasons, they're called mixed accounts. It's going to have separate and community character. You have to get a report that traces the gains and losses on that and gives you a community value and a separate property value. And if you don't get it from somebody that is qualified to do that, you can't trace the account. And that's not good. And so it's worth it to spend, if you have to spend $1,500 or whatever you end up spending for a particular tracing, if you're going to trace out 20, 30, 40, 50, 60, 70,000 more money, that is worth it to you and you need to do it. And if you don't, then no one can help you get that money. So that is actually when you would not be throwing good money after bad, when you would be making a decision that was good for your case that would have a return on investment, because otherwise we can't help you. And let's talk about separate and community property. And there's other examples of that we can talk about as well. Also extending to tracing restricted stock units, doing what we call a short analysis to determine what restricted stock units, also known as RSUs, or different options, what the community and separate portions of those are when you have questions about what's vesting before and after separation or what's granted during the marriage. That's a whole other thing. But anyway, community property. What is community property? This is a good question to talk about. I like to talk about this a lot. If you take away nothing else from this webinar, please take away an understanding, a very base level understanding of community property. Community property is any property that's acquired while you have a community. And that could be assets or debts. When does a community start? In many instances, it starts when you get married. Okay. Sometimes in Washington, if you cohabitated continuously prior to marriage, and we're not going to get into this today, but in general, and here's something you should know, there may be what's called a committed intimate relationship period. A committed intimate relationship period can be an unmarried relationship that's a stable marriage-like relationship for a duration of time. In that kind of a relationship, which also can be ended through a court process as far as division of debts and assets, community-like character attaches to that time. So you might be talking about dividing debts and assets in an unmarried relationship because you might have been in a committed intimate relationship. There is a webinar I did, probably even more than one, on committed intimate relationships. It's a very in-depth topic. So if you have questions about that, I would encourage you to look at it. But there are two times when a committed intimate relationship matters. In a standalone, which means no marriage ever happened, committed intimate relationship, also known as a CIR, and there is a committed intimate relationship period that could be continuous before a marriage that could tack on and extend community as well. And just because you live together before marriage doesn't mean that you have that. It's going to be fact specific to your situation. Okay. So that's when the community starts, when you got married, or maybe when you started cohabitating. That's fact specific. When did it end? It ended when the parties decided that the marital community was over. One person could have decided that and told the other. Somebody could have moved out. Somebody could move downstairs. Somebody could have done any number of things. So when the community ends is when the community ends. And so everything like in that circle from beginning to end, all assets, all debts in there are what we call presumed community. And that means both parties have an interest. It also means name on title does not matter. If you contributed to a 401k during your 10-year marriage, it's your 401k. It's held with your Fidelity or Vanguard or whoever your employer is using. It's in your name only, but your spouse has a community-like interest or a community interest in it. So it doesn't matter that their name's not on it. If you think about a home, if you purchase a home during that time, there's a presumption that it has community character, which means you both have an interest in it. Okay. If you have something that's owned before, that's separate property, or something that's after that separate property. There can be property that's acquired during that community circle that can be separated out. That would include gifts. So if you were gifted something during that time, it's not presumed community. Gifts are separate property by operation of law. But if someone gifted you, let's say, you received a gift and you decided to put it in a community account and start spending out of there, you probably commingled it and it's gone. Same with inheritance. Inheritance is separate property by operation of law as well. So it stays separate property if you keep it in your own account and you don't commingle it or gift it to the community or do anything like that. So those two things can be separated out. Or if you have like earned income, and there's a lot of examples, I'm not going to give them all, but you could have earned income from a separate property business that you established before before you got married or were with this person before the community started, and you could have a business value from that. You could have any number of things that could be separate property that's earned during the marriage. So anyway, that's something to think about as well. There's bottom line you should take away is what's a community? It's the money and the debts and assets earned during the community period. Some things can be separated out. Okay. Once you know what's in the community, and it can take some time, you usually need to know the components of what is community, what is separate, what does that look like. Once we know that, then we talk about how to divide it. All right. So this is the other big takeaway about community property. Washington is a community property state, but we are not a 50-50 state. What that means is some states are 50-50 states, like California is the biggest example of this. That is a community property state where it doesn't matter how long you've been married, doesn't matter how much money the parties are making, doesn't matter what the financial situation is of the parties at separation. That means it's 50-50. Your assets and debts are going to be divided 50-50 no matter what. Doesn't matter. Washington is not. We are what is called a just and equitable state. So what does that mean? It means it depends. So nobody likes that answer, but it's actually true. It means that in Washington, it's important to do a more fact-specific analysis about your marriage. Is it a short-term marriage, a mid-term marriage, or a long-term marriage of 25 years or more? That's going to help dictate what the asset and debt division should look like. Also, what is the financial situation of the parties at the time of separation? Is somebody working and somebody's not because they stayed home? What career level are people at? What's your income? What's your income potential? What is the age of the parties? How many working years do you have left? All of these things matter in figuring out just an equitable distribution and potentially spousal maintenance as well. So those things matter as well. Melissa, are there any questions? I'll take a pause for a moment.
Yeah, one question here in the chat asks, can funds be commingled after separation date, the date when the spouse moves after being served? Can funds be commingled after that point?
Yeah, sure. Funds can be commingled anytime. The question is, what kind of funds? So if you had community money, if you have a community account and you have separate property money, if you put it in there, it's also a question too, though, like if you're helping support the other party post separation, that's not necessarily commingling just because you put it in a community account. That person could be using that for their living expenses. So then it becomes a question of, whether you're paying temporary support or what the purpose is of that. But yeah, you could also take, money you had from an inheritance and you might be separated and put it in an account that's in both of your names and everybody's spending out of it because that's what you're doing during the divorce, and that could potentially commingle it. So yeah, there's two main ways to change community property. I'm sorry, to change separate property to community. One, commingle it, put it in an account. And then it can't just be sitting in the account though. There is no presumption that just putting both parties' name on title makes it community. That used to be called the gift title presumption in Washington. And then there was a case a few years back now called the estate of Borghi. You don't need to remember that, but I like to when I talk about it. So what it means is it used to be, if you put money in an account and both your names on it, it was assumed that there was a gift presumption. You gifted that separate property money to the community. That is no longer the case after Borghi. Now there needs to be putting money in an account with changing the character of the account, changing the character of the assets by executing a writing. That could be a quit claim on a property, putting it in two people's names. That could be putting money in a joint account. It could be any number of things, but that's not enough. You need that, plus you need intent. There needs to be a showing of intent that you didn't just put it in there because you were getting a better interest rate or it was for a refinance or something. You actually intended to gift that money to the community. So you have to have now a writing plus intent to actually change the character of that property. And the legal doctrine for that is called transmutation. You transmute an asset when you change the title in writing and you have the intent to do it and you can prove it. You've transmuted it from separate to community. That's different than commingling. Commingling's like, I put it in the account. Maybe I didn't do a writing because we already had that account. Maybe I just put it in there and it's commingled beyond recognition. It didn't just sit there for purposes of gaining interest. We also put our paychecks in that were community. We start spending out of it and you can't tell what's left and what's not anymore. So that is commingling. So commingling is a way to do that, and transmutation, actually transmuting and changing the character of the assets. Otherwise, it's important for you to realize that the character of assets, character refers to separate or community. That is established at the time the asset is acquired. So if someone buys a home, this is a question we hear a lot too. You guys buy a home during the marriage, everybody's living there, time for the marriage to end, and someone's always asking me, if I move out, do I give up rights to the house? No, the character of that home was established at the time you bought it 15 years ago. If you're moving out now because you're getting separated, doesn't mean you no longer have an interest in it. It's community. That doesn't change because you move out. So that's important for you to know. Just like if you own a home or a condo or something and you owned it before the marriage, before you even knew your spouse, and then your spouse moved in, and you're thinking, well, hey, the spouse has been living here. We've been paying the mortgage with community money. Does that mean there's a community lien on the home? Well, no, not necessarily. The character of that property was established when you bought it before you ever met this person. And there actually is case law in Washington that says if you might have paid towards living there, that is essentially that spouse received the benefit of it because they live somewhere. They would have had to pay money to live somewhere else. So they didn't necessarily acquire any kind of community interest in your home. They received the benefit of living in your separate property home. And any money that they might have paid would be termed essentially reasonable rent. So that's something else to know about property. I think, hang on a second. Okay, Melissa, is there anything else before I move on to my next?
No, go right on ahead.
Okay, perfect. Good. All right. So something for you to think about when you think about what's going to happen in your case with financials. This is the best way that I can explain this. Different times in your case are going to require different financials and different analysis. We talked about gathering financials in the beginning and then having to supplement those as you go on. Different times to seek financial relief is important to know. So you might need to seek financial relief early on in your case. Let's say you need temporary support. Let's say that's child support or spousal support, or you just need an order for someone to pay the household bills, any number of things like that. That is where you would seek what are called temporary orders. You would seek a temporary order to go into place in your case to establish a new normal and a status quo and to make sure that your needs are met during the course of the divorce. Because like I said, divorce is a marathon. It's going to take some time to unwind. It's the most complicated legal contract you've ever entered into, probably without realizing it. Just had a party, had your friends there, and now all of a sudden you're in this legal relationship with this other person. So it's going to take some time to undo it, especially if it's a longer marriage. So you might need some temporary relief. And when you do that, you're going to have to provide the documents we talked about. Sometimes you can negotiate temporary relief with the other party, but more often than not, you're going to end up in court. The court's going to look at your financial declarations, your written declaration describing what happened, hear a little argument from your attorney, and make a decision on who needs what on a temporary basis. And that can, again, spousal support, child support, temporary usage of property, temporary payment, or attorney's fees. Those are very common temporary orders issues. Let's talk about child support for a minute. And this might not apply to everyone here, but I think it's important to at least give a brief discussion and a brief overview. So anyway, essentially, child support is going to depend on the income of the parties. So what that means, and this might be weird for some people, but child support is not the same for everyone. If party X and party Y make a combined income of $12,000 a month or more, they're going to be, and let's say there's 2 kids, the amount of child support for those kids is going to be based on the income, and it's going to be at the top end of the child support schedule. Child support in Washington is one of the only financial areas, probably the only financial area where we actually have a statutory formula. That means there is a child support table, and it goes based on the income of the parties. And then you have kids and you have a statutory calculation. So somebody who's maxed out on the schedule, which is a combined income of $12,000 a month, is going to be getting or paying different child support than someone where the combined income is $6,000 a month or something like that. So it's based on the income of the parties. And then what happens, and this is really important too, when you're calculating child support, there are only going to be certain allowable deductions. There's going to be allowable deductions for tax. There's a mandatory cap on retirement contributions. So if you're putting $1,000 a month into your 401k, you can't claim that. The max that you can claim for purposes of child support calculation is less. So there is a statutory cap on that. There are other allowable expenses, sometimes pension contribution, or which falls under that category, but can be slightly different. Sometimes union dues, different things like that can reduce. And then you're looking at what your net income is for purposes of calculating child support. So once you have that child support number, then you might look at it and let's say party X makes 75% because they're the main breadwinner, party Y makes 25%. So then you take that number and you divide it based on what we call pro rata share. That's 75-25. The person with more nights a month is going to pay the person, with less nights a month is going to pay the person with more nights a month, what we call a transfer payment. Let's say party X makes 75% of the income, but they only have the kids every other weekend. They're going to pay their 75% of the child support number to party Y. Okay. And then we're going to talk about like high level overview of what child support covers. It covers basic life necessities, food, clothing, shelter. It covers those things. Got to buy gas to drive your kid to wherever. It covers those things. Does not covers life necessities, roof over your head, whatever. It's not intended to cover extracurricular expenses. It's not intended to cover out-of-pocket medical. It's not intended to cover, out-of-pocket medical is copays, meeting a deductible, extracurricular activities like sports, non-emergency medical expenses like therapy or braces or other things not covered completely by insurance are also other common things, or work-related childcare as well. So it doesn't cover any of those things. So then how do you pay for those things? You look at that pro rata share, the division of income based on the child support number. Is it 50-50? If you make the same amount of money, sure. Is it 55-45, 53-47, 70-30? It could be any number of things. It depends on your situation. So making sure you have accurate child support worksheets is really important. Also, if one party is covering the children on insurance, they may receive credit in the child support worksheet for the portion of the premium that covers the children. There's other ways to deal with that too. You can do a proportional reimbursement, but the easiest way and the cleanest way is to include it in child support worksheets if possible. So you're going to get a deduction and a credit for that. So there's a lot more that could be said about child support. I think there's even a child support webinar you could watch if you really wanted to know. There are deviations down in child support, usually for time spent with the child or other reasons. In a very, very, very rare occurrence, there might be an upward deviation for above the standard calculation. But that's the thing about child support. It's kind of the simplest thing we do actually in family law. It's on the numbers, we say, because there's not a lot that you can do to change it. You have to have financials to support it. And it's really kind of what we figure out. So usually last after the parenting plan's been decided and realistically who's going to be paying and who's going to be receiving support. And the statutory formula really guides who gets what. So you can agree to other numbers if you want to, but you've got a pretty a pretty good basis. And it's important to note too that child support and parenting plan are two issues where you can't just agree to whatever you want. You can, but the court is the final say, and the court will want to make sure that if there's a deviation, there's a basis for it, and that it supports that there's an adequate level of support for the children in both homes. If there's not, the court will refuse to enter it because the court and the state have a vested interest in making sure your kids are supported. So anyway, okay.
We do have one more question here.
Sure.
So if a spouse is a beneficiary to an inheritance that has yet to be dispersed,
Mhm.
can that future money, separate property, be a consideration of spousal maintenance as far as what he could
No,
afford to pay?
no.
So it
If you
doesn't factor into
if they
like,
don't have the money, if that person hasn't died, like whether it's being passed through a trust or a will, doesn't matter. Doesn't matter. It's speculative. It could be changed. You don't actually have the money. This happens a lot. So it's a great question that you asked, whoever asked it, because someone might say, oh, well, when his dad dies, he's getting this. You have to disclose it. It has to be known, especially if there's discovery requests asking about it, but it's not a basis for determining future spousal maintenance or anything like that. And it might feel super unfair, but it is what it is. In a long-term marriage of 25 years or more, it can be more of a factor because then we're talking about equalizing income. We're talking about future interest. But even then, it's really, really tough because if the person's not already receiving the money, if they're already receiving the money, that would be one thing. If they're not and they don't have the money, then
if the person has already passed and it just hasn't been dispersed yet, same story.
it depends. That's pretty fact specific. It
Yeah.
depends on the terms, depends on, yeah. So if the person's already passed and it's like in probate or something, that's one thing.
Mhm.
So, yeah.
Another question is, how does the court view medical financial needs for both the spouse and the children?
Medical financial needs. Well, for the children, it's going to be based on proportional share. If your child has, and we talked about upward deviations a little bit ago, if your child has like really extreme medical situation, it requires a lot more support or in-home care or something, and someone makes a lot of money, it might be a reason for an upward deviation. But in general, somebody's going to cover the medical insurance. Someone is going to pay a portion of the premium or have that covered. And then out-of-pocket medical is going to be proportional share unless there is a basis for other agreement. So that's something for you to know. For the other spouse, that could factor into spousal maintenance. I do want to touch on that after this, just briefly on spousal support, which is also known as spousal maintenance. And that is kind of the Washington term for what other states call alimony. It's a payment from one party to the other for support. So anyway, in those kinds of situations, if someone has medical needs and is unable to work or unable to get back to work, that can be a basis, depending on the length of the marriage and the circumstances, upon which to establish a need for spousal maintenance. So that's something, or maybe more of the property. Washington, my friend Kim Muska, she's a financial advisor at UBS. She's also, if any of you have been to our meetup, she's usually on there with me. She likes to say, and I'm gonna steal this from her, so that's why I'm mentioning her to give her credit. She likes to say that Washington is a choose your own adventure state when it comes to divorce, and it really is. It's not like California where everything's straight down the middle, 50-50. They even have a statutory formula for maintenance. We don't have any of that. So that kind of means you can choose how you want to do things. Like, let's say someone's disabled. Let's say someone's going to get more of the property because they are not going to recover financially as fast from the divorce. In that kind of a situation, maybe there's maintenance involved, maybe not. Maybe there's a bigger disproportionate division of the assets in lieu of maintenance. Maybe maintenance is paid in a lump sum at a small prepayment discount. There's all kinds of different things like that you can do. It actually is great because it gives you more flexibility in your settlement, but it is very much a choose your own divorce adventure state. That's how I look at it. Okay. I want to talk briefly just about spousal maintenance before we're done for the day. Spousal maintenance, there's two kinds of spousal maintenance. One is temporary maintenance, one is post-divorce maintenance. Post-divorce maintenance is more often than not the biggest issue in a case when one party's not been working or incomes are very, very different. And there's a lot of discretion when it comes to maintenance, but there is case law and there is a statute that guides when maintenance is appropriate. It just doesn't give you like a formula or anything. So when you think about short-term, mid-term, and long-term marriages, those are very important when you're thinking about spousal maintenance. Why? Because there's a general guideline for what is appropriate in maintenance cases. If you're in a short-term marriage, which is really like 0 to 5 years, a short-term marriage, the principle necessary essentially is that those marriages are backward looking. Nobody's been in the marriage long enough to rely on the community, right? So because, and thinking about this, keep in mind that we are this just and equitable state. Court wants to try to do what's fair. They're like, you haven't been married very long. Nobody's relied on the community very long. We're going to look back. Parties should basically keep what they came in with and just divide the community down the middle and go on their merry way. That's a really general way to deal with short-term marriages. Okay. However, if there's a big discrepancy and it's a longer short-term marriage, 5 years or more, maybe someone gets a little more of the property. Maybe. Maybe somebody gets a little post-divorce maintenance. Maybe. Maybe somebody gets a limited amount of temporary spousal maintenance during the case.Maybe. But generally speaking, spousal maintenance is awarded typically on somewhere between 3 and 4 years of marriage equals 1 year of maintenance. And probably in a short-term marriage, it's more closer to a 4-to-1 ratio, or maybe no maintenance at all if it's a 5-year, 4-year marriage. Depends on the situation of the parties, but it's not going to be much. A midterm marriage, which is usually a shorter midterm marriage is 6 or 7 years. A longer midterm marriage is 23, years, 24 years before you hit long-term territory at 25. In those kinds of situations, which is most marriages and most people getting divorced because it's a bigger range, a disproportionate division is more likely to happen. You're going to look at how long people have been married. And then when we talk about maintenance combined with a disproportionate division, you're going to be like, okay, so let's really think about it. If someone was married, like let's just say someone was married 16 years, right? If I'm married 16 years and I'm looking at a 4-to-1 ratio, that's 4 years of marriage. I'm sorry, of maintenance. On a 3-year ratio, it's like 5 1/3. So where's the negotiation range of risk? Somewhere between 4 years of marriage and probably 5.5. Anywhere in there is probably going to be a reasonable place to land for negotiation. That's important for you to think about. Do courts ever go 2-to-1? No, not really. Can maintenance go longer? Maybe if someone's disabled or has medical issues that are going to require more support, that's a possibility. And then you could be in a situation in a long-term marriage where maintenance may or may not be appropriate. If both of the parties are retired, maintenance in a long-term marriage typically only is going to happen if there needs to be an equalization of Social Security benefits, other retirement that's not equalized through asset and debt division, residual pension payments, anything like that. But the principle in a long-term marriage is really to equalize people. In a midterm marriage, disproportionate's more appropriate because you want party to rehabilitate themselves. And they'll say that the party that's not going to make as much money is not going to recover as fast. So that's something for you to think about. But maintenance, the takeaway there, 3 to 4 years of marriage usually equals 1 year of post-divorce maintenance. A lot of people want to know, if I pay temporary maintenance, does that count? No. A temporary maintenance order is for temporary maintenance. It's not going to, and you could pay temporary maintenance for like a year or more if you're in a King County case where the case schedule is going on for a while. You can even receive it for that long. If you're getting it for a year or more in a short-term marriage, the court might consider that. But if you're in a midterm or a long-term marriage and you paid or received temporary spousal support, nobody's going to care. It's not going to reduce your post-divorce support. So anyway, we've talked about community property, talked about separate property, talked about child support, and we've talked about spousal maintenance. We talked a little bit about gifts. We talked a little bit about inheritance. We talked a little bit about the need to get actual valuations. We talked about the need to provide statements. Hopefully you're taking away from this what the starting point for getting those statements should be. It'll help you out. Or that hopefully if people ask you for them, they're not trying to make your life difficult. We're really just trying to help you. So, and I can't give you advice if I don't know. I'm just saying me as the attorney that's in this Zoom right now, but any attorney, not just me, cannot give you credible advice guessing what separate and community is or guessing what your assets are. Or you might send me a spreadsheet that's like, here's what we have. I'm like, great, I need to see it. So I can't give you advice otherwise. We're here to help you, not make your life worse or more difficult. I don't want to do that. Every family law attorney is busy enough that no one needs to like labor over your case to try to get paid, which is another common misconception. We want to help you as efficiently and quickly as possible so we can give you the information you need so you can move on and you can get what I would call an equitable settlement that's going to allow that. So thanks for being here. If you have further questions, feel free to reach out. Feel free to go to our YouTube library where we have a lot of videos there and we're always putting up more. Yeah, so I hope that helps. Take care and have a nice day. Bye-bye.